The contractual engagement is for 1 year and extendable for another period of 2 years. In such a situation, we are not inclined to interfere with the impugned judgment or the order without approving of the reasons contained in the order of the district magistrate dated 31/10/2013. Sri Verma submits that on account of the changed circumstances and the alteration of the status of the Gram Pradhan of the village, the appellant will be losing the opportunity to apply again for the said post in case fresh selections are held. In fact, the candidate to be engaged now has to be a person of the caste of the village Pradhan. This being a provision of law, the situation cannot be altered by us through a judicial intervention so as to extend any benefit to the appellant. In such a situation, even otherwise, the employment cannot be offered in contravention to the aforesaid policy of the government. The appeal therefore cannot be entertained. The same is accordingly dismissed. This brings us to the stand taken by the respondent state authorities in their counter affidavit in paragraph numbers 6, 7, 14 and 16 that in the original assessment proceedings the petitioner had not produced the copy of the whole contract, and further it had produced the books of account for verification, and the same were not examined by the assessing authority while framing the assessment order, and therefore there are no books of account. While it is true that the court had, while entertaining this writ petition, directed the state to file a counter affidavit stating whether the petitioner had produced its books of account, etc., and state has pleaded in the negative, we find it difficult to accept the correctness of that averment made in the counter affidavit in face of specific findings and observations recorded in the original assessment order itself as discussed above, to the effect that the petitioner had produced contract documents and also its books of accounts. In that situation, the district magistrate may send notice to members of the board by special messenger, giving them 7 clear days before the date of the meeting. In that event, the legislative intent and purpose requiring sending of notice would be fully achieved, although in that event the rule of presumption as laid down in the subsection would not be available, and if a challengeable was made by a member that no notice was received by him, the deeming provision will not be applicable, and it would require proof that the notice, even though sent by ordinary post or by special messenger, was actually served on the member. The emphasis on sending notice to members by registered post and for publication of the same in the manner directed by the district magistrate is directed to invoke the presumption as contemplated in the last sentence of the subsection. In the absence of presumption, it is always open to a party to prove that notice, though sent in a different manner, was served on the members. In view of the above discussion, I am of the view that even if the notice is not sent to the members by registered post, the meeting cannot be held to have been illegally convened. Stop.